All right, here we are. Hi, this is Anthony Parent of IRS Medic, and it's early morning, May 2nd, 2023. We had a bunch of interesting news happen yesterday, some good, some real good, some a little bad, and we'll discuss that. Really, what we're talking about in this episode is bringing a lawsuits against the U.S. federal government against citizenship-based taxation. And let me just give you a little primer about where we are, how we got to the place, this awful place that we currently are. With there you can see my last slide. There is a reason for hope. I'm teasing what there is. And really, a lot of what we're talking about, how the federal government gets away with all the nonsense it does. Our last episode, we talked about how there is a significant gulf between what the FBAR regulations say and the FBAR law says. And a lot of this stuff that these regulators get through, it's because of this thing called Chevron deference. Now, Chevron is a case we learn in law school in administrative law. That's like the number one case in administrative law. And the case kind of stinks for all of us. And it kind of ruined everything because basically it's this is what Chevron was. Essentially, the Supreme Court was a rubber stamp to any federal regulation. That was really the effect of it. So anything a regulator said, good luck with your challenge, no matter how good your challenge was. The Supreme Court's like, we don't care. We're just going to rubber stamp everything. And it just, led me to conclude, like, why do we even have a Supreme Court? Why don't we just buy a rubber stamp? It'd be a lot simpler and we'd have the same result for the most part. It's actually, but if you've been paying attention to the Supreme Court, something interesting has been going on. And that since 2015, and if one counts King versus Burwell, all 9 justices have at least signed on to an opinion explicitly holding that Chevron should not apply in a situation where our law school textbooks said it would. So every one of them has a problem with Chevron, so much so it would contradict our textbooks. And then also, this is the big thing that happened last year that surprised me. I couldn't believe it. This was just this was a monster of a case, West Virginia versus EPA. Supreme Court went ahead and said, you know what, we have to apply the major questions rule as a way of enforcing a constitutional prohibition on a law that delegates legislative authority to agency. The so-called non-delegation doctrine. That is, you can't pass a law that says, okay, we're gonna pass a law and we're gonna let the regulators decide. And that's a lot of times the way the laws are written. They're written so vaguely, and we'll let the regulators fill in the blanks of these major policy questions. And so that was a massive win and a huge wake-up call that maybe something is happening in the works. And then this happened yesterday. This is huge. Loper Bright Enterprises versus Raimondo, Secretary of Commerce. It's a case about that the regulations say that federal observers must be allowed onto some certain fishing vessels. The law doesn't say that the boats have to pay their salaries though. And so that's what this is about. The law says, okay, you have to make room for federal observers on your boat, but it doesn't say you have to pay their salaries. And so that's what this is about being challenged. What does the law say? What the regulations say? Why are we going to grant the court this deference where the law is silent? Maybe there's just no grant of authority. Why can't it just be that they didn't give any authority? So this is an amazing case that's coming up, and it's going to be decided next year. So, it could be May, June, this time next year. We are discussing how Chevron was overruled. And if it's overruled, well, then there's a host of regulations that are going to be challenged. And many of the ones that are being challenged now may find a success where they would not have before. Now, this is where I want to come into us for our discussion on citizenship-based taxation. Where does this idea come from? Many of you know that we are the only country in the world that has this citizenship-based taxation thing. And Cook versus Tate is the first time we encounter it. It's a Supreme Court case in 1924. And there it claims the 16th Amendment applies to all income sources despite complete silence, really the lack of authority on the matter by the 16th Amendment and complete silence by the actual law that never even that bothers to define an individual. Is it an individual someone under 18? Is it an individual someone over 21? Is it an individual someone who is mentally incapacitated? Is it an individual somebody who is not in this country? Those are what's completely silent. And well, guess what happened? We have regulations that fill in these blanks. It's in the regulations that we find our definitions for individuals. Now, further compounding the issue is a case called Afroyum. Afroyum, I believe, is wrongly decided while it appears on the surface to help us. Because in this case, what it was about was somebody left the United States to live in Israel and swore allegiance to the state of Israel. Then they decided to come back to the U.S. and say, "Oh, actually, I'm a U.S. person. I'm a U.S. citizen. I didn't give up my citizen, and you have no right." Because Congress passed a law to say, "Hey, look, if you go overseas, commit some sort of expatriate act, like swearing allegiance to another country, you lose your U.S. citizenship." Well, the Supreme Court in that case says, "Oh, no, 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 no. Nobody. There can't be any law that Congress creates that would destroy anyone's citizenship." Which is actually not what the law did. It actually recognized that someone else destroyed their own act. The government didn't. The government just simply recognized, by your own act of what you did, you have expatriated. Therefore, you're no longer a U.S. citizen. So people look at this like, well, this is a good thing. This means the government can't go and destroy your citizenship. However, what it's done is it's made unwilling citizens out of a whole bunch of people who have committed expatriating acts, who have gone ahead and lived totally different lives. This law is crawling them back, dragging them back, like Dred Scott, the fugitive slave law. You come back here, Mr. U.S. citizen. How dare you think that you could escape our rule? So with that, that is where we are now. The tax regulations define an individual. The law does not. Okay, and the federal, and this is just a thing to understand. The federal individual income tax does not define individual. So the questions we need to ask is, all these regulations that are going around defining individuals, what they are, is this a major policy question? Because we have some silence. The regulations never did it. Now we do have a Supreme Court that said, well, it's everywhere, but I believe there's some limitations to the Cook versus Tate holding anyway. But now we're left with this thing. It's like, well, there's a U.S. Treasury. Is it entitled to deference for creating CBT in its regulations? Now, yesterday we had some bad news as well. Monty Silver's transition tax lawsuit was denied cert. That wasn't great news. But, here's the fact. With West Virginia and now Loper Bright under consideration, there can be no doubt the Supreme Court is looking for big changes. Now, most of the public doesn't understand it, but these big changes can have big impacts. And so with that introduction, I want to introduce my guests, John Richardson and Keith Redmond. Gentlemen, thank you so much for joining me today as we discuss this. John, I want to start off with you. You have some CBT lawsuits you're looking to fire out here. So can you tell me, why don't you just give me a description, your reaction to what I just said before you get into that?
Well, Anthony, you talked about a couple of years of law school in, a short period of time. Okay, so generally, seems to be no question that Treasury regulations are coming under increasing scrutiny, and or their interpretation of that. Certainly, we see that in the Bittner F-bar case. We see it in the recent, was it Farney or whatever, the 6038, whether those penalties are
right,
case, right? We see the interesting case, I can't pronounce his name, but you can easily find it, this Philadelphia police officer from Poland who challenged his penalties. This is another one, which not quite in the family of challenging the regulations, is at least scrutinizing the behavior of the IRS and applying the stuff. And then of course, in the context of West Virginia and EPA, it would appear to me that the days of what's that movie? Because I Said So or something. It seems to me that the days of simply delegating to Treasury and closing the door and letting them do what they want appear to be on the way to being over. Now, how long that's going to take, I really don't know, because, of course, the tension is the whole point of delegating to administrative agencies is because the people who make the laws don't have the expertise to understand them or administer them, etc. So, why not delegate the rules to people who are likely to interpret them, and sort of a combination of the way that's most administratively expedient for them. And on that point, uh, Monty Silver's transition tax lawsuit comes to mind because the basis of the lawsuit was that they didn't apply the Regulatory Flexibility Act, even though they said they did. And then another very interesting case was this a Federal Express case decided May 1st, where uh, the position of Federal Express was the Treasury was simply creating a regulation under the transition tax that was the complete opposite of what the statute said. And I think what they called it, they were interpreting in a way that was that reflected simply their pure policy objective, right? So it would seem to me that there's going to be a growing recognition of the difference between the statute, in this case, the Internal Revenue Code, and the regulations, as there should be. And I think that the inevitable result of that is going to be that Treasury is going to be losing more and more of these things, as time goes on. Now, we move this into the whole CBT area. And
before, I just want to check in with our resident layperson, Keith Redmond, to make sure we didn't lose him. Keith, I have a question for you, and this is sort of the thing I want you to understand. Do you understand, as our resident layperson, do you understand that the amount of litigation and favorable decisions? I haven't encountered this. This is new. When I started this channel in 2009, it was hard to find topics to discuss that were interesting and or possibly helpful. And now it's hard for me to keep up every day. And yesterday we had two big newses. There's so many things. Do you understand what's going on here?
I do understand, as you laid it out from the beginning of this podcast. I think the only thing that I don't understand is the Monty Silver case, meaning that the Supreme Court is not going to hear it. So that means that, and you please correct me if I'm wrong, that the regulations will stand vis-a-vis the transition tax. So isn't that I see, that's where I'm a little confused.
Yeah, no, it's a total loss. Yeah, it's a total loss, and you don't win every one.
Right.
Supreme Court, and this
so you look at the trend.
The
so
Supreme
it's looking
Court
at the
has
trend.
the Supreme Court has a limited docket, and so I love Monty's case. I really want him to win. I can't stand the transition tax; it's totally unfair. But if I was able to choose one case to get cert, I would definitely choose Loper Bright over his case because Loper Bright could wind up giving the relief to the transition tax.
Okay.
So that through a different means, through a different argument, say, well, look,
okay.
So I wouldn't give up on a transition tax challenge at all. His challenge, that specific way, he reached the end of the road there, and the Supreme Court just didn't. And their thinking could be, hey, why do we care about this one case? We can decide something that will decide this case and many other cases too. So, okay, he's going to lose. And that's the way they are. They'll just let someone, okay, you're going to lose, and go back out there.
Okay.
It is a loss losing that one. But the bigger news and the better news is that the Chevron deference, which basically is that rubber stamp to all these regulatory agencies to do whatever they want, regardless of what the statute says. And really, when the problem that you have, and I think this is the problem you have, is where the statute is silent. That this is where the regulators go and fill in the blanks. Oh, the statute's silent. Well, we should be able to do this because the statute's silent. And they're not looking at that as like, well, maybe because we're not authorized to do that because it didn't give us the express grant. And that's the problem you have is like, well, they didn't give us the express grant, so we're going to imply that they wanted to do this, which clearly doesn't make much sense at all, and has led to sort of the out of control situation that we do have right now. So back to you, John. So where are we headed with now? Do you have any plaintiffs right now for lawsuits that you wish to bring, or you're looking for plaintiffs? And what are kind of challenges are you looking to bring?
Yeah.
Okay, number one. Okay, I'm just part of a group. Okay, so it's not my lawsuit or this.
Okay.
It's the group.
It's a collective effort.
Okay.
Whatever. But
So who's part of the group?
well, maybe Keith wants to address that.
Okay.
Sure. Well, we have, we have a working group. So John's part of the group. I'm part of the group. We have Laura Snyder, that's part of the group. We have Fabian Lahagra, who's part of the group. We have Mark Zell, who is the lawyer of record, if I can use that term, who is spearheading the CBT lawsuits. We have Karen Alpert, who's part of the group. We have Suzanne Herman, who's part of the group. So we have a number of key individuals. So this is a collective effort from everyone who is adversely affected by CBT.
Right. And what Keith just mentioned, these might not be names familiar to you, but these are household names to me. These are all the big wheels in this. These are all people who've been guests on the channel, people who have done cases work for me. So this is really your all-star group. So fantastic. So Keith, would you have plaintiffs, or are you looking for plaintiffs?
Well, we do have plaintiffs that have been secured, but we're still looking for more plaintiffs. The idea is to have plaintiffs who are adversely affected in different ways by citizenship-based taxation. So each plaintiff, if I may say, has its own flavor, if you will. And that's why it's lawsuits, plural, and not lawsuits, singular, meaning that there's going to be a series of lawsuits filed and different, and forgive my layperson knowledge here, but the different federal courts around the United States. So that way it can be tackled, if you will, from many different angles. And with that, there'll be a public relations arm to be able to get out the messaging that needs to be disseminated in regards to each of these plaintiffs and each of these particular lawsuits. And the common thread through all of them is to attack citizenship-based taxation. I mean, there's so many different groups who are adversely affected, especially those who are actually in the U.S. tax system as Americans overseas, who are being harmed. So it really runs a broad scope of people who are being damaged by CBT.
Oh, that's amazing. Now, John, I have a question for you. Are there any claims that you're hoping you could bring? Is there anything out there that you're like, you know what, this is really a type of claim that I wish to bring? Where do you think do you sense some weakness? Do you think there's?
Yeah. Okay. So just to back up a little bit here and try to provide a little more context for this. Okay. I think that one could view this in two different ways, right? I mean, one could view this from the point of view of making a claim that citizenship taxation on its face is unconstitutional. I personally think that's a difficult, not impossible, but a difficult claim to make. All right. I mean, I think taxation by its very nature is designed to be vicious and oppressive. And, although the United States is the only one that's the official member of, citizenship as a criterion for tax residency, it's not like other countries aren't horrible as well. And there's and part of the problem you've got here, right, is that in the United States of the 21st century, the tax code has replaced the Constitution anyway, as the Constitution. I mean, everything is subject to the tax code. You can't even bring a lawsuit unless you've paid the taxes. So without taking a position on whether any of this lawsuit or lawsuits would include a claim that citizenship taxation in and of itself is unconstitutional, what they clearly would recognize and be based on is the simple fact that American citizens living outside the United States are not only subject to U.S. taxation, but subject to a variant of it that's far more punitive than what resident Americans have to deal with. I mean, I'll give an incredibly basic example that anybody can relate to. You know, the mutual fund issue, for example. You know, you buy something. I always use the same example: Templeton Growth Fund. In Buffalo, it's, you know, a good investment. You buy the same thing in Toronto, Canada, an hour and a half away, and it's you know, it's an obvious deferral for U.S. tax evasion, right? Et cetera. It's called a PFIC, a passive foreign investment company. Now, leaving aside the question of whether citizenship taxation is on its face unconstitutional, as offensive as it clearly is, it seems to me there's a second level, and I don't mean a lower level, I mean a parallel level of questions. You know, whether somebody, just because they live outside the United States, can be subject to, you know, rules that essentially treat their normal day-to-day life from a U.S. tax perspective in a way that's so much more punitive than if they lived in the United States. Now, you know, it's interesting. We look at the Monty Silver case, for example, and, you know, all of these legal cases, you know, Anthony, are based on some kind of legal principle and necessarily exclude others. But win, lose or draw, the Monty Silver case is a very, very clear example of how a U.S. citizen trying to run a small business outside the United States is obviously, you know, subjected not only to more discriminative and punitive, but a vicious, vicious, vicious confiscatory form. I hesitate to even call this taxation. It's so vicious, right? You know, just a punishment, if you will, for having the temerity of, you know, trying to, you know, set up a small business outside the United States. And there are a number of examples that, you know, that one can see on this. I mean, there's the whole factor reporting stuff. I mean, it was very interesting how incredibly upset resident Americans were with the idea that their bank accounts would be reported to the IRS, right?
Yeah. And
You know,
I just brought up our slide again about Ephraim, and this was actually and some I believe it was one of our viewers. I can't remember who, but they had this comment on the Isaac Brock Society about Ephraim. They said, you know, it basically, you know, we have the second part: Congress cannot enact laws or engage in practices that result in the forcible destruction of U.S. citizenship. And you know, we're passing, you know, these regulations that, and the way they're interpreted, it's essentially destroying U.S. citizenship. That's you know, I concur.
Exactly.
Exactly right. That's sort of the thing. You're like, well, the law says you can't destroy U.S. citizenship, but boy, have you made it a real piece of garbage, right? I mean, that's kind of the thing. It's like, okay, so you think it's something like that, a challenge like that, perhaps, or something different?
well, I do think that. I do think that, and you know, let me elaborate on that a little bit. So, what the Ephraim case, the majority in the Ephraim case says, and by the way, it's a 5-4 decision. Okay, this is not, you know, everybody signing on sort of thing, but the guts of the case is simply that the statutory automatic expatriating rules that existed at the time, naturalizing a citizen of another country, what have you, or voting, as examples, are unconstitutional because the 14th Amendment says anybody born in the United States is a U.S. citizen, right? I mean, that's it. That's a constitutional provision. So what the decision says on one level is that, well, you know, I mean, if the Constitution says if you're born in the U.S., you're a U.S. citizen, you know, they can't then have these laws that strip you of your citizenship, you know, for doing this kind of stuff, right? So what you know, there's a great paragraph towards the end of the decision that basically says that Congress can't engage in things that result in the forcible destruction of citizenship. Okay. And that's the part of the decision that blog post, which I actually wrote, that they were just reproducing something I wrote a long time ago over there. So if Congress can't do things that result in the forcible destruction of citizenship, right, then that means that the things that effectively force people out of U.S. citizenship, I think are arguably unconstitutional. Now, I want to add to that, though, that this is true for Americans who live outside the United States, right? It would not be true for Americans who live inside the United States. So I think that the claim probably needs to be a little more narrowly defined, in that for Americans abroad, these kinds of rules result in the forcible destruction of citizenship, which they clearly do. I mean, there's no doubt about it.
Right. Yeah.
I have clients who fly all around the world and pay a lot of money to be rid of U.S. citizenship, right? And you think they're doing it, because they want to. They're doing it because they have to.
Right. There's a lot of money.
Yeah, they have no choice. No choice at all.
They really have no choice. Well, I mean, the U.S. government say, well, of course you have a choice. You're just not going to engage in the things you need to do to protect your family, for retirement planning and normal financial planning. That, buddy, is what it means to be an American. Americans do not do those kinds of things. They do not do those kinds of things.
And now what John is saying is absolutely right. And this is why he says, and I agree completely, is that the U.S. tax code and its regulations trump the Constitution, because it's always it's clear the government doesn't care about your rights. They care about you as a taxpayer and making sure you do what they tell you to do, or else. Even though, again, we have some gaps in the law here where it was really never decided. You think anything about the challenge of that? I remember this is something we've talked about a few times. How the regulations define individual, and that there's a regulatory fix to citizenship.
Yeah, that was an article that I co-authored with Laura Snyder and Karen Alpert. Well, obviously, I think that's good because I was involved in that article. Obviously, I support that. Right? Yes, I do. Okay, because if the theory is that individual can be defined by regulation, obviously Treasury could amend the regulation and not include citizens. So that's clearly a conscious choice, and it can be fixed through regulation. Okay.
I want to make sure. What email? If people are interested in joining and supporting this, where should they email? Who should they contact? I want to get that up.
Well, so I don't know what the various addresses are, but if you want to just put up Citizenship Solutions at protonmail.ch or whatever that is. Right. Or I don't know.
And you could put up my email address as well.
Okay, what's your email, Keith? What
email? It would be the US_overseas_advocate@outlook.com.
Just send it. That's a lot. That's complicated.
Here we go.
Solutions.com.
There we go. US overseas advocate outlook.com.
Yeah, US_overseas_advocate@outlook.com.
And Citizenship Solutions.
Yeah.
At protonmail.com, right? You want?
Yeah, you can have that too. Yeah.
Right. All right. So.
And then to keep up on the goings on as far as what's happening with the CBT lawsuit on Facebook, anyone can join the American Expatriates for Residency Based Taxation group.
I think we have a lot of viewers from there today. That's nice for them to join us. By the way, I want to get to some comments. I think we have some comments here. This is I think I'm going to show you this one. This is I'm not sure what to call S_DW. Maybe you can let me know what to call you. I need something a little short for you. Great comment reviewer here. This is just sort of the point. I've argued some time over whether or not federal tax applied to someone based on citizenship alone, but have been told the law is the law, right? That's the thing. We've been told the law is the law, and we've been told Chevron's the law in law school. Suzanne. All right. So Suzanne says, all right, thank you, Suzanne. And absolutely right. And then Suzanne follows up with this comment too. Jefferson maintained the right to expatriate, and that people forget what the British were doing to us in the War of 1812. Why the War of 1812 was fighting is that the British were saying you've never lost your British citizenship. So we kind of have some historical precedents for what's going on. The British didn't want to give us up because they wanted us to fight, and the U.S. government doesn't want to give us up because they want to tax us and control us and everything.
Yeah, look, I don't know that these historical precedents are really that analogous to what's going on today. The U.S. Okay, first of all, the way the U.S. tax laws work, they are, sure, they're applied to citizens, okay, but they're not particularly taking the position that people who are not citizens are citizens, okay. They aren't doing that. It's just that the U.S. has a broad sort of definition of citizenship. I mean, the reality is that U.S. citizens can renounce. Okay, it's punitive, it's difficult, but they can. So it's not really what the British were doing. What the British were doing was claiming eternal allegiance, to the king, et cetera, et cetera. Well, no, because you couldn't renounce it, right? This was
Okay, all right, I get it. All right, I see your point, but I mean that's sort of, and I would just say the U.S. makes it so difficult.
Oh yeah, absolutely, absolutely.
Okay, you can, but it's not easy, and they make it hard.
It's not easy and it's expensive. But I think that the commentary on this would probably be, if it can be effective at all. It's because this is so complex, it's hard to get anybody to listen. But I think it would be more effective, if it didn't draw, back to these historical precedents. However, I will say this, that the 1868 Expatriation Act, or whatever it is, right, was a statute that claims to give people the right to expatriate. However, there's some confusion about whether that applies to Americans or whether that applies only to people who want to be Americans.
Yeah.
Okay, interestingly. And the Ephorium case, I mean, I would like to think that that the decision can be read broadly enough to include a constitutional right to renounce. I'm not 100% sure that it does. But a second thing that I want to get into this conversation is a lot of people sort of bandy about this taxation without representation, right? And, what the British were doing, et cetera. I think that's a very, very bad analogy, okay? Because the British were imposing taxes in some form or another on their own colonies, okay? I mean, it may have been unfair taxation, it may not, but it was taxation on their own colonies. Really, one must understand that what the United States is doing is way beyond that. It is not imposing taxation on its own colonies. It is imposing direct taxation on other sovereign countries. So there is no comparison between what the king was doing in the 1700s and what the United States is doing today. And frankly, to make the comparison, I think deflects attention from how unbelievably offensive and unprecedented the United States is actually doing. In fact, to compare the United States of today to the oppressiveness of King George during the years leading up to the American Revolution is, quite frankly, a gross insult to the memory of King George.
Yeah, there's a lot of myth making for sure, and that goes into, that's a topic that we've discussed. Let's see here. We got yeah, right. Just sort of here's a Mike Green has a comment. This is just, the law is the law, right? And that's just sort of the way people dismiss you. It's like, well, which law are you talking about here, right? I mean, it's just something to think about when people just get out of control and just sort of go to, I think, arguments they can't support. It's like, well, why do you say the law is a law? Because you don't have a reason. You're just saying authority is authority. Here's another great, here's another great question, from a rhetorical question from Garrett Anderson. how much members of Congress understand the problem, and of those who do, how much do they care? John, you want to handle?
Yeah.
Yeah. Okay. I mean, first of all, you know what I'm going to say, because that's what I've been saying for years. It's not that they don't care. It's that they don't care that they don't care. That's the real problem.
Yeah.
But I think it's important to add, this comment is focusing on two things. How much members of Congress understand the problem. Now, the way this thing is discussed, and this is a great mistake, is focusing on this from a U.S. point of view, whether they can tax their citizens or something. But as I've written in a couple of blog posts, the only contextual meaning that citizenship taxation really has is the United States imposing direct taxation on the tax residents of other countries. That's the only real contextual meaning it has, right? Because that's the only thing that captures the idea of reaching into other countries, claiming their tax residents as U.S. tax residents, and then taxing them on their non-U.S. source income, right? Now, the problem is, and I think this is a very, very great problem, is to allow this discussion to take place in the context of all that's going on here is the United States imposing taxation on its property, right? Citizens who are perhaps, outside the United States, when the real issue should be the United States imposing direct taxation on the tax residents of other countries. That's the real issue. Now, you put it that way, and this is something that I'm beginning to write up, okay? I think it becomes, frankly, an issue of international law.
Yeah.
Right?
Yeah.
Now, the reason that I think that it hasn't come up yet, or a possible deterrent, is, of course, the saving clause in the U.S. tax treaty. Because, look, treaties are generally understood to be a lot of what international law is about, okay? So you have these U.S. tax treaties that include a saving clause where the other country stupidly and incomprehensibly agrees to allow the United States to impose direct taxation on their own residents, right?
Yeah, we've seen that, and that was we've seen Croatia. We did a podcast on that.
Yeah, I mean, there are different variants of the saving clause, but they're in basically all these U.S. tax treaties. Now, let's say you were able to get rid of. Now, the fact that this is in the tax treaties is, I suspect, a reason why there hasn't been a really open discussion of whether this violates international law or not. But let's say you get the tax treaties amended so that, and there are various ways this can be done, but so that they don't include a provision, that is this savings clause that, where the other country agrees the United States just come on in and scoop up its own residents, they can't do that. In other words, sort of a statement like this in the savings clause, of course the United States is free to define tax residency in any way it wants. It just can't apply it to our tax residents, okay? Right? I mean, that's the way I think.
Yeah, right. That seems like it was going.
So you can get rid of these, and there are varying ways of doing this. But let's say that you get people to understand this, you get rid of the savings clause, then the issue becomes, because there's no treaty where people agree to this, then the issue becomes, oh my God, can the United States actually walk into our country, claim our residents as isn't this, I mean, how is this different from just, an invasion? I mean, this is, shouldn't this violate international law?
Yeah.
All right. So, I mean, I think that's the direction this has to go.
That does seem like, that and the other countries kind of need to stand up for themselves, which they don't seem to do. They seem
they don't understand. I don't think that I think there may be a growing awareness, okay, but they don't fundamentally understand this issue because, if you look at, you had Mike Breen's comment on a minute ago, and Mike Breen has been a great warrior, I think, and deserves a special shout out here over the years.
Yeah, right on, Mike. We appreciate
Shout out to you, Mike. Okay, keep up your great work. Okay, your great educational initiatives. Or whoever Mike actually is. I don't know if there is, whatever. Okay, but in any case, at some point, I think that, this is an issue that has to come up. And I think that it will come up when, I don't know. But I mean, if we put this in the context of, all this discussion right now, I mean, even in the United States, they recognize that as the dominance of the U.S. dollar as a reserve currency declines, right?
Yeah.
That U.S. power declines, et cetera. And I think there's more likely to be discussion
There's yeah.
of these treaties, et cetera. But
Well, I wanna check in with Keith, and, thank you, John. And I wanna just check in with Keith. Keith, and this is really what I wanna make sure people who are watching this to say, "Oh, yes, I am interested in potentially suing the government and being a plaintiff for something." Keith, who are you looking for? Can you just give us a sort of like welcome, like, maybe a call to action for people and let them know that you're not, you are who you are. You're a nice guy. Um, uh, can you just explain who you're looking for? People who you're looking to contact you.
Yeah, I mean, we're looking for people who have actually been harmed by citizenship-based taxation. So those individuals who have, I mean, John can elaborate a little bit more, but who are in the U.S. tax system
Well, I
and have,
actually, yeah.
yeah,
Yeah, go ahead, Keith.
yeah, those individuals who are in the U.S. tax system, whether they're in the tax system as an individual or they happen to have a business overseas and they're not able to conduct business as a result of dealing with two incongruent tax systems.
Okay.
These are the key individuals that we are looking for.
All right. Well,
So if you feel,
I have a, I
specific.
have
so
a,
if so let me finish. So if the
yeah, sorry.
individual feels like they fit that particular criteria, to just reach out to John or me, and we will speak with them and see how we can take it further from there.
Right on. Well, I think Suzanne left another great comment, and this is sort of who sort of how would we get a plaintiff like this, but maybe something like this. Um, if one's mentally incompetent, and they
Yeah.
can't renounce, give care on their behalf. And, Suzanne has a follow-up comment with that, and this is, I used to deal with helping parents, caregivers with special needs, kids and young adults. For the accidental American falling into that category, they're not going to understand, and that's again, that when we talk about the definition of individual. Individual means someone who is not mentally competent. Okay, well, then how do they comply with something they can't possibly grasp,
Right.
understand? They can't sign it. Someone has to do it, but it's a non-delegable duty.
Yeah.
And so I think if we could potentially get someone like that to expose, well, yeah, we need to define individual to someone who is mentally competent at least. Uh, do you think that would? I think is that something? I think that would be a
No,
strong.
absolutely.
Yeah.
Absolutely. That would be an issue as well. I mean, the key people who are, the ones that are going to be harmed right now are the ones who are trying to adhere to the U.S. tax compliance
Right. That's right.
under citizenship-based taxation. They're the
So
ones who are being harmed.
there you go. So yeah, send in
How about
send
some
it.
specific
Um,
examples here? How about some specific examples? Okay, I think that's a little too vague.
Is it?
Start
Okay.
start from the principle that the U.S. is imposing effectively a different set of tax rules, all right, on
Yeah.
American abroad.
Right.
And, this leads, obviously to a combination of taxation, reporting, penalties, et cetera. Now, some specific examples of people who I think would be helpful. One, PFIC taxation.
okay.
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 People who held mutual funds for years have sold them, have, been hit with these exorbitant taxes, plus the compliance costs, right? I mean, these are absolutely not. These PFIC laws came into force in '86 before there was even a mutual fund industry. Okay, this is just trying to apply this to something that was never intended. So PFIC. Okay. Secondly, anybody who's trying to run a business through a corporation
Yeah.
and are getting into the CFC rules. Now that would include three types of things. Okay, obviously the transition tax. Interestingly, I think the work Monty Silver has done, okay, is perhaps a predicate for the transition tax. We've got the guilty thing, and we just have good old fashioned subpart F income, right, where investment income is taxed differently if it's run through a corporation. Now, the point here, I think, is that it may be that from a U.S. perspective, a corporation is nothing but a sacred instrument of tax evasion. But in other countries, corporations play the role of private pension plans. Okay, for example, medical doctors in Canada, etc. So really, this is an interference with their ability, to have pensions. Okay, a third one would be sale of the principal residence. Okay, not from the point of view, but including the point of view that it's being taxable, but also the phantom capital gain issue, right? How you can owe U.S. tax when you've actually lost money,
Yeah.
etc. Okay, so I
That
think,
little thing there too. There's a good one, right? Yeah.
and I
Yeah.
think then we have things like foreign pension plans, which I think the Australian
Well,
superannuation is probably the best overall example, right? It interferes with anybody living in Australia, to participate in that form of retirement planning. Next category and would be the whole penalty regime. I have talked to so many people over the years who've been assessed just vicious life-altering penalties, for not filing a form on time. That first of all, it's I'm not even sure they had to file the form. Tax industry, listen up here, okay? Not sure they even had to file the form. But if they did, there's no way why would anybody, right, who's born outside the United States, technically U.S. citizen, and receives a gift from a parent who's not a U.S. citizen, why would they even imagine that they have to report that to the U.S. government, right? But of course,
you're not right. It doesn't touch your concern, right? It doesn't.
then they're subject to all these penalties.
Right. So those you
Right.
actually kind of described. You sort of
Right.
described my client list. Every one of those issues,
Yeah.
I've had at least one client affected by that. So I'll send out an email to my clients. Hopefully, some of them are.
Let me ask you something, John and Anthony, or specifically on this one, John. Would another individual be someone who is self-employed in a country that does not have a totalization agreement with the United States, where they have to pay self-employment tax to the U.S.? Would that be someone as well?
I don't know. Maybe. I think it's worth a discussion. It certainly exacerbates the problem. All right. However, I don't know. Is that hugely different from being in the U.S.? I don't know. Maybe. I think it exacerbates the problem, particularly if it results in double Social Security tax.
Well, that's what they're doubly taxed. They have to pay self-employment tax in the country they're in, as well as the U.S.
Not going to help with that. I think certainly that. I think probably the whole renunciation issue the exit tax. Anybody who's had to pay an exit tax, renouncing U.S. citizenship, when the exit tax is based on particularly non-U.S. pensions, right? Americans abroad are basically paying exit taxes on assets that have nothing to do with the U.S. that lived in the U.S. Right. This is just, it's shocking. If you describe this to somebody, you talk about U.S., they say, well, you mean that applies only to U.S. assets, right? This is what they say. And actually, it's in fact the reverse. For many of the people renouncing, probably the overwhelming majority, the exit tax will apply to their non-U.S. assets, specifically their non-U.S. pensions. And this is going to result in a distribution, right? A fake, a distribution, meaning probable fake income on a pension that has nothing to do with the U.S., right? This is amazing stuff. So I think people who've had to pay exit taxes, I think, are possible candidates for this. But who are not candidates are just people who, oppose the extraterritorial tax regime in general. Because
I would suggest, but I would encourage them to file their own lawsuits. Maybe not with you, but I would encourage anybody to make these challenges. And I think that's what we've been seeing. We've been seeing a lot of people making a lot of challenges and things that weren't even challenged before. Seeing it and seeing a lot of attorneys get some incredible wins that are starting, are really surprising and really give you like that word called hope.
Yeah. So the wins are. What's interesting is what all these wins have in common, and I think we ought to do a complete podcast on this, right? They all have in common is, the first thing you do is you actually read the statute, right? The Internal Revenue Code or title. You actually read the statute, and you try to figure out what it means, and then you measure what either the regulation is or the IRS conduct, right, against that. And what we're finding is that where Treasury is losing these things, it's just based on courts ruling that no, you don't have the authority to do that.
Yeah. Well, I think that'd be a great idea to have a podcast because we want to inspire everyone. And it says, hey, look, let's not get down and let's not get down in dumps, but let's get out there and show like the Supreme Court is doing things. It is amazingly, and so I think that would be a great one to do next. We're about out of time here. Keith, final remarks.
Final remarks.
Final remarks. I have your email up so people can know where to email you if they're interested. Anything
Exactly. No, we just need support for the CBT lawsuit, specifically the PR arm of it, the public relations arm. For those who may not be a potential plaintiff, but they can support that.
Yeah.
That would be very important. And again, this is a collective effort.
Yeah,
this is for everyone that has to endure CBT.
Right on. All right, John, concluding remarks.
Well, no.
Okay.
We've said it all.
We've said it all today. Well, thank you so much. Now I am I am working on. I just didn't have the time to record it. I know some of you have been promised my rendition of "It's a Wonderful Form" based on John Richardson's lyrics to the great song "It's a Wonderful World." I did practice a little bit. It touched me. I got to be honest. I don't want to overhype it, but it's going to be incredible when I get to that.
Anthony, you don't need to practice it. Okay, things that come from the heart, a strong conviction, never require that kind of practice.
It really, when I came around to "It's a Wonderful Form," it just I nailed that note, and I mean it just whoa. And I really thought about those wonderful forms out there.
Bro, could you give us a 10-second? I mean, it's the start of my day, Anthony.
I know you look like you need to get going here. All right, what is our? Let me get the. What is it? I think to myself, what a wonderful form. There we go. All right, I'll do. I'll give you a little bit more for. All right, hopefully maybe on the next.
I think that. So you're singing in the choir, right?
I sing in the church choir. Yes, as a tenor. Yes, I do. It's
I think there's so many great songs out there that can be rewritten.
Yeah, this is the one. I mean, that's this.
What about
so our next podcast? Do you did we have a topic for our next one, or do you want to do the victories?
I sent you the topic.
Okay, you did. Okay, so our next topic. Okay, great.
Yeah, we're going to continue. I think the forcible destruction of citizenship.
Okay, so you want to say on that one? Okay, what we exactly mean by that? All right, great. So look for that one. We had a great audience today. We got some one more comment here. All right. Okay. Donated to the crowdfunding to end CBT. There's Suzanne. Right on. Thank you. There you go. There's something you could do. Fantastic for that.
Well, actually, I have a concluding comment.
All right.
Be like Suzanne.
Thank you, Suzanne. Thank you so much. And by the way, that is Mike Breen's real name. So we appreciate your courage and conviction and your bravery, Mike. Thank you so much. Everyone, thanks so much for joining us. This is Anthony Parent of IRS Medic. Thanks again for watching.